Yes. So the hearing is in the matter of case number TCD 001-2020 before Justice Sir Richard Field. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Charles Russell Speechleys, LLP. Lead counsel is Justina Stewart. The first defendant is represented by KBH Canon. Lead counsel is Bushra Ahmed. The second defendant is represented by MB Kemp LLP. Lead counsel is Brian Kotick. Thank you.
Yes, yes, Ms. Stewart.
Your Lordship, may I first of all check what documents you have, in what form you have them?
Yes. Well, I've got the e-bundle on a separate screen on a separate device. I've also been provided with hard copies of the bundle, and sometime late yesterday, I was provided with the claimant's supplemental documents, which are not agreed. These are mainly concerned with the application that I understand you're going to be making. And I got another bundle, I think, just containing indexes and so on, which we can ignore for the moment. So I have read the 7th witness statement of Mr. Smith, and I have read the 2 witness statements that you are going to apply to be allowed to use, despite the fact that the time by which the evidence had to be served has long passed.
My Lordship, before my learned friend starts, there are other documents that we sent this morning. It's a letter dated the 22nd of November, as well as 3 authorities. The case of...
Well, wait a moment. You'll be referring to those, will you, in reply to Ms. Stewart's application?
I will be, but it will be helpful if you have those before you as well. They were sent to the registry this morning at around 10 o'clock to be placed before you.
Right. So where are they going? Will they be in an electronic form, or will they have been sent to me separately by the registry?
Well, I'm hoping that they would have been sent to you by the registry separately, because we wrote to the registry this morning, emailed them and asked them to place them before you.
Okay. Now, Charlotte, can you help with this?
I haven't actually had an opportunity to look at the authorities yet, although I'm not sure I would have taken it on a fax in any event. But...
Well, let me just see. I'm going to have to come off the screen for a moment.
Your Lordship, if you permit, we can email those to you.
Well, wait a moment. Let's have a look. Wait a moment. No, I've not been sent these. They've not come. They certainly haven't come to the usual
Sir Richard,
email address. Yes,
I'm in the process of emailing them to you as soon as possible. Typically, when we get documents sent less than 24 hours before a hearing, it's not always guaranteed that they would be delivered.
No, I understand that, Shahin, of course. Send them to the iCloud address, please.
Will do, sir.
Okay. Well, we'll just mark time while you do that.
While we're marking time on that, in terms of other matters, there's preliminary issues. There is the question of UAE law. In Ms. Bushra's skeleton argument, for the first time and somewhat to our surprise, she appears to be alleging that UAE law rather than DIFC law applies. We say this can be dealt with shortly, but it seems that before we start trial, we should clarify this matter.
Well, I'm not sure it's necessary to do that now. I mean, this case essentially turns on the evidence. as to what was agreed and what was undertaken or not undertaken in respect of this proposed sale and purchase of the Bitcoin. And I want to get into the evidence. We of course have to hear your application. But at the heart of this case is the evidence to be given by the witnesses on both sides as to their relationship, their dealings with each other and the like. So never mind about a law or whatever. That's something for a later consideration. Now, I've received the email from Charla. Now let me see. So there's a letter from KBH. I'll just upload that. Wait a moment. And let's see what else there is. And then there are these authorities. Oh, well, I'm not interested in the chronology at the moment.
Your Lordship, may I invite you to perhaps take a few moments to read the letter, because that is
Well,
short.
all right, just wait a minute. I refuse to be mugged and hassled in this way. I need a little space in order to get these documents uploaded. Right, well, now I'm going to take a brief look at these authorities, and then I'm going to hear Ms. Stewart. Let me just ask the second defendants. Can I take it that, Mr. Kotek, you haven't sent anything overnight that I should be looking at relevant to this application? You'll be making oral submissions.
That's correct, Your Honor.
Okay, well done, good, all right. Right, I'm looking at these authorities, so this will take a few minutes.
Your Lordship, perhaps just to sort of direct you, if I can invite you to read the case of Nihal, the Tatneft case you're probably familiar with, but I will be taking you to Nihal, so that's the relevant authority.
Nihal, all right, okay, wait a moment. Thank you.
I don't appear to have Nihal.
No, I don't have it either.
Nihal Mohammed Kamal Brake?
No.
No, hasn't arrived. I've got Global Energy Horizons. And I've got PJSC Tatneft. That's it, and the letter.
It has been sent. Perhaps if we can send it again to the registry.
Well, get that done straight away, please.
It is. Thank you, Your Lordship.
And if I could have a copy, if all the advocates could have a copy, please.
Yes, of course.
Understood.
Oh, no, I have got Nikau. It was lurking, and I now see it.
Thank you.
So you no need to send that. I'll look at that right away. Where's this from?
Ms. Ahmed, I don't seem to have received that authority.
We'll send it again.
If you could send it to us as well, that would be appreciated.
All right, I've read break, which is Nihal.
Grateful.
Oh, I think it was actually mislabeled on the attachments.
My Lordship, can I also check that you have read our letter of the 22nd of November?
Well, I'll have a quick look at that.
Grateful, thank you.
All right. Yes, all right, I've read that.
Grateful, thank you.
Well, Miss Stewart.
Yeah.
Are we ready?
Indeed, yes.
Yes, go ahead.
So in essence, the application to rely on the further witness statements, they seek to clarify and correct mistakes that were made in Al Ali 1 and Saxena 1, mistakes for which apologies are very much extended to the court. The purpose of filing these witness statements and making this application is now is not just to correct those mistakes, but also to prevent time at trial being spent by Mr. Al Ali and Mr. Saxena correcting their witness statements during examination in chief. We have a very tight timetable, and it was thought that this was this would be a more
But there's quite a lot in these proposed witness statements which is not concerned simply to correct what is stated in the earlier witness statements.
sorry, also to clarify, yes, but
Well, it doesn't. There's, well, when you say clarify, there's quite a lot that is fresh in the sense that there's nothing said about it in the first witness statements. It's within the context of the events covered in the first witness statements, but there's quite a lot which is not simply pointing to statements in the first witness statement and accepting that they are erroneous and the right position is as follows.
Well, I think the witness statements do seek to refer to the paragraphs of the previous.
Of course they do. They refer to paragraphs which they now say are not correct. But there are also, let's have a look at Mr. Ali's fifth witness statement, proposed witness statement. Well, look at paragraph 34 and what follows. From paragraph 34, more or less to the end, there's a reference to paragraph 73 in the first witness statement in paragraph 40, but it's not really correcting anything. But this is new, and that's the TABARAK Commission. It may be in the context of matters which have been previously dealt with. But I think you're constrained to accept that in, for instance, in paragraph 18, 21, 22, 23, these are dealing with, introducing matters of fact which are not in the first witness statement.
Well, what they're trying to do is to ensure that to take the court and the parties through the relevant evidence to explain how the account opening fee and the commission came to be agreed. But in particular,
why wasn't that done in the first witness statement?
Well, it is regrettable, and I think if I could just go through the basic points, which are that the mistakes were made and these important issues were omitted purely by mistake due to the time pressure, which has been set out at length in Mr. Smith's seventh statement. Less than ideal. I'm not going to pretend otherwise. Miss Ahmed has said this has been some kind of tactic to try and derail trial or to try and make life difficult for the defendants. Well, that's not the case. The team at Charles Russell has been working round the clock. I was instructed and I started looking at the papers in detail after the PTR, and as your lordship will be aware, the PTR was somewhat time consuming. These points were picked up when I started looking through the papers. This was not a matter of responding to Miss Ahmed's skeleton argument or anything like that, and any suggestion that this is some kind of, and to the timing of which, this is to use Miss Ahmed's wording, the timing is clearly designed to hamper counsel's preparation for trial. Well, that would suggest that the claimants deliberately filed witness statements with mistakes, but with respect, that's rather ridiculous. They didn't. To be quite frank, the CRS team the timetable has been extremely difficult. there have been multiple problems uploading documents onto Caseline. The team at CRS have been working, they've put in more than one all-nighter to try and get documents sorted. And I'm afraid this is why, and unsatisfactorily, this has come late. But there is no tactical ploy here. The purpose was to correct and to clarify. The purpose was to set out the evidence by way of a witness statement rather than elongating trial yet further, and also to give the defendants notice rather than these clarifications being made, or at least some of them being made, in evidence in chief. So it gave them the heads up, which surely has to be consistent with the overriding objective.
Well, at the moment, it seems to me that in substance, you are really putting yourself in a position of seeking the mercy of the court.
Yeah.
What I'm being told is that for one reason or another, the first witness statements were inadequate and in some measure inaccurate. And when you came on the scene, these shortcomings were discovered. And so there's been work round the clock to try and shore up the position with these two witness statements. And the question is whether, in justice and fairness, the court ought to admit these witness statements, notwithstanding their lateness and the impact on the trial. Now, when I hear the submissions in opposition, of course, I will be taken to authorities which show that it is only in exceptional circumstances where this sort of application will be granted. But I will want to hear in some frank detail, without exaggeration, from Mr. Ahmed and Mr. Kotek as to what time would be necessary for these witness statements to be taken on board so that counsel are ready to cross-examine these witnesses if, and it's a big if, I admit the statements. So, Ms. Ahmed, let's start with you.
Ms. Ahmed, you're on mute.
Thank you, Ms. Stewart. Your Lordship, can I start by saying, and I say this without any exaggeration whatsoever, that the claimant's lawyer's conduct falls way below what is expected from an international law firm with experienced lawyers. And sat on this end of the table, it feels as if that they have been conducting this trial by ambush. We've heard from Ms. Stewart today about the mistakes that were made and that there's been work around the clock and that it was difficult to pick up these mistakes and that they weren't deliberate. But just on that note, my submission is that had somebody been paying attention to any of this, those mistakes would have been picked up and they could have been responded to in responsive evidence. And I'll give you one example of that, Your Lordship. If we turn to Mr. Al-Ali's first witness statement, that's at section 6.1. It starts at section 6.1. And the paragraph that I'd invite you to open is paragraph 40.3, page 614.
So it's his first witness statement, Mr. Ali's first witness statement. Just I've clicked on that, which is in section 6. And what's the page, please?
614, page 14.
614. Well, I can scroll down to that. Take a little bit of time. Yes, I'm there. Go on.
Paragraph 40.3.
Yes.
Mr. Al-Ali says he returned the signed copy of the agreement on the 20th of December 2019. So that's one reference, Your Lordship, that I'd invite you to take into account. The second reference where we say that they could have responded in responsive witness statements is at paragraph 40.5, where Mr. Al-Ali says, on around the 20th of January, I signed and returned the addendum to TABARAK. I exhibit a copy of the addendum. Now, for your reference, my lordship, the copy that was exhibited was an unsigned copy.
Yes.
Mr. Al-Ahmadi, in his first witness statement, which is at section 6, page 61.
Well, just tell me what it says.
Well, Mr. Al-Ahmadi says at paragraph 42, also it appears that HUOBI did not sign the agreement until sometime after the 19th of January 2020. So he makes reference there in his first witness statement about when the agreement may have been signed. Then at paragraph 55 of his witness statement, he then gives evidence about the agreement being signed on or around the 19th of January and that the addendum was never signed. So the point is that Ms. Stewart is saying that these mistakes were inadvertent, but we say they weren't, because hadn't somebody read Mr. Ahmadi's witness statement, these matters could have been dealt with in the responsive witness statement, which they weren't. And therefore we say that it is trial by ambush, notwithstanding that, Your Lordship, you've also referenced
well, listen, Miss Ahmed, just listen to me carefully. You must be very careful when you make these sorts of allegations. I can well understand a submission that there has been incompetence and slackness on the part of the claimants in preparing the witness statements for these witnesses. But I am not prepared to entertain the suggestion that this is all a deliberate tactic. That's a most serious allegation, and you shouldn't be making it in the circumstances of this case. You have a lot to be said in favor of your position. Now, don't spoil it by overreaching yourself. Now, what I want to know, is how much time would you require to digest these new witness statements to be ready to cross-examine the witnesses if I admitted the evidence?
Your Lordship, first of all, can I just say my apologies, and I take note of your observations. Number two, Your Lordship, there are wholesale changes that have been made to a number of particular issues in this case. I would have to go back and revisit the entirety of my cross-examination to see where the inconsistencies are, and then, of course, reconsider my cross-examination in light of the new evidence.
Yeah.
And I'm very conscious of the fact that we only have 5 days currently listed. Yeah. I'm also conscious of the fact that, Your Lordship, you want to get into the evidence. However, what I would say, Your Lordship, is that if Your Lordship is permitted to allow these witness statements, then I would want a full opportunity to cross-examine Mr. Al-Ali. And therefore, Your Lordship, I would seek the indulgence of the court not to curtail the witness, the cross-examination of the witness, and to allow me to put the questions in light of this new evidence. Yes. And in those circumstances, Your Lordship, what I would like to do is not take too much time in dealing with this new evidence, because I may be able to do that as part of my cross-examination, but only if the court indulges me in allowing me the time that I need to cross-examine Mr.
Yes. Well, give me some idea, and I'm of course sympathetic to the situation that both the defendants are in. Clearly, time is going to be needed, if I were to permit this evidence in, for you to reassess your cross-examination, and no doubt you may have to take some instructions on this or that matter. Doing the best you can, give me some idea of how long you would need before you could begin your cross-examination if these witness statements came in?
Well, Your Lordship, I would say probably another half a day.
Is that half a day of this trial, which is limited to, what is it, about 4.5 hours? Or is that half a day that God gives us of 24 hours, or working, in your case, 12 hours?
Your Lordship, I would say half a day of an ordinary court day.
An ordinary court day, very good. Yes. Now, again, I have a lot to think about here, and I'm far from having made up my mind in any respect. If I were to let this evidence in, the claimants are going to have to pay the wasted costs involved in the time which hasn't been spent on progressing the trial, but the time that will have been spent dealing with this new evidence, for which there is the lateness for which there is little excuse. Now, when you say half a day, I mean, could you get on board in, say, 2 to 3 hours?
Probably.
Thank you very much. Now, I've looked at the authorities, and of course I am familiar with a number of authorities. These days, there's a great emphasis on making the courts work efficiently. Timetables are promulgated with the intention that they are complied with, and consequences will flow if they are not. I have also to keep in mind the overriding objective and where the balance of justice lies. So thank you very much for your submissions. I'm going to ask Mr. Kotek for his submission. Yes, Mr. Kotek.
Thank you, Your Lordship. First, to address the admissibility of these witness statements, I would like to echo Ms. Ahmed's statements about the substance of the changes made in these witness statements. These are not mere mistakes. They do change the actual theory of the claimant's case on the facts relating to beyond what my learned friend Ms. Ahmed had said about the signature of the asset agreement and the addendum, but also how the claimant came to introduce via the intermediary Rudolph to TABARAK, and who at TABARAK, that intermediary introduced the buyer to. So these are fundamental differences in these witness statements. Now, as to the reasons provided by Ms. Stewart and regarding why these came in late, my learned friend has said that this is because she had come on the scene a bit later and only came to know of these inconsistencies. But that is not what is provided in the reasoning in the witness statements. The reasoning in the witness statements say that the witnesses themselves came to know of these inconsistencies, and they attributed to certain things as these were prepared in a rush, and my wife was due to give birth in the instance of Mr. Saxena, and in the instance of Mr. Al-Ali, this was just because there was significant time pressure and without the benefit of having enough time to refresh my memory. So these considerations really don't warrant a huge delay in submitting these corrections. And my learned friend has said that we were provided notice for this, but notice must be deemed reasonable in the circumstances. And notice the day before the trial, when we are trying to prepare quite this arduous task of preparing these cross-examinations, is hardly notice at all. When we look at the impact, it is not just these 2 to 3 hours that we need to rearrange our cross-examination and change some of the references. We are now functioning off an incomplete and inaccurate chronology, which the parties have yet to agree upon due to the lateness of the claimant's counsel in providing that, and also a trial bundle which is incomplete and doesn't reflect, an accurate representations of the facts in this case. So on that basis, we do share the first defendant's concerns on the admissibility of these witness statements. However, we do appreciate that the court does want to move this case forward and move it forward in an efficient manner. We also share Your Honor's concerns that this is an evidentiary hearing, and a lot of these inconsistencies can be brought up and addressed in cross-examination. So with that, we do leave it to the court's ultimate discretion, and we're happy to take it the time as allocated.
Well, thank you very much. Now, just thinking ahead, again, this is all hypothetical because I'm going to take an adjournment to carefully consider all the matters in play here. But Ms. Ahmed, as representing the first defendant, would go first in her cross-examination. And if she were to have 2 to 2.5 hours to be ready, that would leave us around about 2 hours, effective 2 hours today. Now, there's no agreed timetable for the trial, but Ms. Ahmed, give me a rough idea, you can't be more precise, I understand, of how long you're likely to be in cross-examining both these witnesses.
I would like at least 5 hours to cross-examine Mr. Al-Ali. And Mr. Saxena, I have indicated 3 hours, but I'm happy to reconsider that. And the reason why I give an indication of 5 hours is to take into account the new evidence and put in the inconsistencies to the witnesses, obviously, and also dependent upon the answers that we receive from the witness, Mr. Al-Ali.
Well, if you'll forgive me for saying so, and I speak of many, many years' experience of trials in commercial matters, you don't need 5 hours to cross-examine this first witness. You really don't. I know it's difficult because this has been sprung on you, but I can't imagine that you would need, in fact, more than about 3.5 hours. And if you needed more, then we would look at the situation. Of course, I'm not going to limit you to any particular time frame. And then, so far as Mr. Saxena is concerned, what do you think?
Well, if I'm, well, first of all, grateful that you won't curtail my cross-examination, but if I'm allowed the sort of full opportunity to cross-examine Mr. Al-Ali, then I can perhaps consider Mr. Saxena and reduce my time for Mr.
Yes, I follow. There's some trade-off there, I understand. Now, this is clearly going to have an impact on the length of the trial. There's been talk about an additional 6th day, and I've been asked to consider a 6th day. I just want to have a look at my diary, if you'll forgive me just a moment.
Your Lordship, we have actually come up with a trial timetable. The council spoke yesterday,
Yes.
and this trial timetable isn't agreed because, well, the second defendant agrees to it, but we didn't agree to Miss Ahmed's, for example, 5 hours. If I could take you to that trial timetable. That trial timetable does suggest that more than 6 days is going to be required. One of the reasons for this is we do have a shorter day. Of course, the transcribers do need their breaks, including it's a term of their contract that they are entitled to a break for lunch, for example. If I could perhaps take you to that trial timetable.
Well, I'm not sure that's necessary at the moment. At the moment, 5 days would conclude on Monday, the 29th of November. Are we agreed on that?
Yes.
It begins today, and we would have today, tomorrow, and Thursday, then Sunday, which would be 4 days, and then a fifth day would be on Monday. Now, how are the parties placed if we were to go into Tuesday and Wednesday of next week?
Your Lordship, I think Wednesday may be a public holiday.
Ah, yes.
And there
In
is,
fact, I think it's 2 days, isn't it, the public holiday?
yes, and I think there might be some talk about the 30th being, not the, I beg your pardon, yes, the 30th being a public holiday, although that hasn't been confirmed yet. But certainly the 1st of December is a public holiday, and I imagine the 2nd of December also to be a public holiday.
Well, I wonder if the case progression officer who's listening to all this could help. What view does the registry take about how many days are taken by public holiday, please?
It's still not confirmed yet, but we might take November 30th and December 1st as public holidays. But it's still not confirmed.
As matters
right.
stand, I have an obligation on the 30th of November, which I haven't yet managed to shift. So
Yes, all right. Well, it looks to me as if we have to accept that it's likely that both the 30th and the 1st would not be effective for this. Well, what about Thursday the 2nd and Sunday the 5th of December?
Thursday the 2nd is a public holiday, Sir Richard, because it's the UAE National Day.
Well, so is the registry contemplating 3 consecutive days of public holiday?
I'm not quite sure yet. But December 1st, December 2nd are for sure public holidays. The 30th most likely will not be, but we still don't have confirmation. But it's most likely not going to be a public holiday.
Well, in my diary it says it's St Andrew's Day, and I don't think there are that many Scots in Dubai. There may be some. I think we'll proceed on the basis that 30th will be an effective day, and I would want that to be. If I let this evidence in, I would want clarification on that as soon as the registry is able to do so. But I quite understand that that may take some time, because matters will have to be weighed up and considered in the overall context of the working schedules of the registry. Well, let's assume for the moment that we could have a 6th day on the 30th. Now, what's happening?
I thought Ms. Stewart had an obligation on the 30th. Is that still correct?
yes, I do, unfortunately.
Oh,
but
yes.
I've been trying to
Thank you
shift.
for reminding me. I'm sorry, Ms. Stewart. I'd forgotten that. You have an obligation on the 30th.
Yes.
Well, what are the chances of you shifting that?
I have been trying. I've been trying to shift as many dates as possible.
Well, perhaps we better assume that the 30th, the 1st, and the 2nd are non-effective days. Now, it seems to me we need 2 more days. There's Sunday the 5th and Monday the 6th. Or alternatively, there's in the following week, I'm in another matter on the 7th and the 8th. It's not a Dubai matter, but that's a fixture. But I could do the 9th and the 12th. So the options are, it seems to me, Sunday the 5th and Monday the 6th, or Thursday the 9th and Sunday the 12th.
Your Honor, before we decide, I think it might be prudent to ask the expert witnesses who will be examined that day of their availability as well.
Yes, of course. No, certainly they must be consulted. Well, I think what I'm going to do is this. I'm going to adjourn for at least 15 minutes from now in to allow myself to consider how I'm going to decide this application. And during that time, I'd be grateful if those who would have to attend the extra 2 days are consulted as to their availability. We know what we're talking about. It's either the 2nd of December and the 5th on the Sunday.
Your Lordship, not the 2nd. The 2nd is a public holiday. I think it was the 5th.
Oh, I beg your pardon. No, you're quite right. I'm so sorry. You're quite right. I'm confusing myself. So it's either Sunday the 5th and Monday the 6th, or
I thought you said the 9th and the 12th.
on the 9th and the 12th. Yeah, that's
Yes,
right.
and Your Lordship, just in terms of inquiring about availability of potential witnesses, our expert is in the US, and therefore there's a 12-hour time difference. So I think it will be about 1 o'clock in the morning where he is. So it may be that we take some time in inquiring about his availability.
Yeah, sure. My impression at the moment is that there's broad agreement on how this is likely to have happened with the mnemonic and the purchaser or his agents being able to have sight of the first 6 and putting those together with his 6. This fraud was practiced, and I think I'm right, but you tell me if I'm not. There's we're not going to have an enormous amount of time spent on the expert witnesses, are we? I mean, there's a fairly broad agreement. There may be 1 or 2 bits of the various hypotheses.
You would assume so, Your Honor, but there has been a supplemental expert report submitted by the claimant just recently that we also have on the file.
There's another expert's report, is there?
There's been an amendment made, and therefore there's a supplemental report flying around, although there's no application before you, Your Lordship, to admit that supplemental report, and nor is there any agreement for that supplemental report to be admitted.
Yes, all right. Okay, well, we'll keep an eye on that. All right. Now, it's 1/2 the hour, and I would like to resume in 15 minutes' time to see where we are, and for me to consider my decision. So we will resume in 15 minutes. Thank you very much.
Thank you, Your Honor.
Thank you.
Well, now, before I take matters further, can I be told where we are if we need the additional days? Are we going to be in the earlier 2 days or the later 2 days? Or are we not able to do either of those 2 sets of extra days? Ms. Ahmed, what's the position from your point of view?
Yes, Your Lordship, we've contacted the expert, and I'm told that he has a flight on the 6th of December, but he can do the 5th of December, and we're just checking about the 9th and the 12th.
Okay, he can do the 5th.
Yes.
Right.
My Lordship, can I also add as well, just in terms of the timing, because of the 12-hour time difference,
Yes.
we may have to factor in the time that their cross-examination starts. And that's not only for D1's expert witness, but I imagine also for the claimant's expert witness, because the claimant's expert witness, as I understand, is also in the States.
Yes, that's right. We haven't been able to contact him yet as regards his availability, I'm afraid, due to timing.
So at the moment, the 5th, so far as the first defendant is concerned, is a viable extra day. What about if both experts could be done on the 5th? Ms. Ahmed, how's your team placed if we go into the 6th?
I beg your pardon, I didn't catch the question.
If we go into make the assumption for the moment that both experts can be done on the 5th. Your expert can, subject to timing difficulties. We may have to sit at some extraordinary time in order to accommodate the expert. Now we need a day in addition to the 5th. How are your team placed, and others who would have to attend if we went into the 6th?
It's a viable date for us, Your Lordship.
Now, at the moment, you're not sure what the position would be for the 9th and the 12th.
That's right.
Yeah, so Mr. Kotick, what's your position?
Fortunately, Your Honor, we are flexible and our expert is flexible for the 4 days proposed.
Right. Now, I made it clear some time ago that closing submissions would be in writing. So what we're concerned to do is to complete the evidence. And it seems to me that the chances are good that we will be able to have the experts, which will be the remaining witnesses, to have the experts on the 5th or the 6th, if the 6th becomes necessary. In other words, I take the view that the chances of being able to find these extra 2 days within a relatively short period of time from the last effective day, which would be Sunday the 5th, are reasonably good. Would anyone want to seek to persuade me to the contrary?
Your Lordship, I'd go back to the point that the trial timetable, when you actually break it down, I'm not sure if we will have closed the evidence by, for example, the 5th or indeed even the 6th, just because of the hours in the day. If I could take you to that trial timetable, it might become apparent.
Yes, all right. Let's have a look at it.
It's at 27-65.
So we're going to find page 27-65.
Yeah.
27-65. Right page. And here it is. Yes.
Now, this timetable was based on us reducing the amount of time that for cross-examination by Ms. Ahmed of Mr. Al-Ali, and also reducing the amount of time of cross-examination of the experts that Ms. Ahmed had. But even then, it can be seen that we end up going into day 8.
Day 8?
Yeah, and we've tried very, very hard to take in, because of course the issue is that we have we have the lunch breaks, we have a shorter trial day. We also have 3 experts, not 2 experts. We have cross-examination of each witness by 2 parties.
Well, at the moment, it does seem to me that if this evidence comes in and Mr. Ahmed has the next two and a half hours to take on board the new evidence, as we're going to be sitting until 6 o'clock Dubai time, we probably have about 1.5 hours of cross-examination, something like that today. Now, I've looked at the witness statements and I'm aware of the issues in this case, and I must say, I would have thought that the factual evidence, in other words, the cross-examination of the factual witnesses, ought to conclude by close of play on Sunday the 28th. These events all occur on a number of days. There are clearly meetings on the day of the transaction and so on. This is and the seems to me that the case can be effectively put in cross-examination so that the factual witnesses really ought to be finished by Sunday the 28th.
Well, if Your Lordship, if we go through the timetable, for example, Miss Ahmed was indicating she would need, well, her starting position is 5 hours. Your Lordship's indicated 3 hours, I think.
Yeah, I said 2.5 to 3. Yeah.
Okay.
Oh, so no, that was the time to be allowed. Yes, that was
yes.
the time. Yeah, 3 hours, let's say. Yes.
So if we assume that, for example, for my cross-examination of Mr. Ahmadi, I have the same, and when you factor that kind of rationale throughout the timetable, looking at the timetable that I've drawn Your Lordship's attention to, it's not entirely clear to me how we're going to get through all of the evidence by the end of Sunday. And we really have done a minute-by-minute analysis, taking into account the breaks that the transcribers require.
Well, are all 3 teams available on the 14th, 15th and 16th of December? Can you look at your diaries?
I know that I'm available and that CRS is available, but until our expert wakes up in the state, we don't know what his availability is.
As far as the second defendant is concerned, counsel is available and the expert has confirmed his availability as well.
Well, realistically, how long is it going to take to find out which of the postulated days that we would have beyond Sunday the 5th of December. The possibilities are, just to remind ourselves, of the 5th and the 6th, and the 9th and the 12th. Now, if all those days could be effective, and if at least the experts can be accommodated, they can be taken out of sequence if necessary. If the experts can be accommodated within those 4 days, just to repeat, Sunday the 5th, the 6th, the 9th, and the 12th, then I'm confident that this trial can conclude down to the point where the evidence is in and written submissions can be provided subject to a timetable. Does anybody dissent from that? So that's an additional four days if they're all free.
Yeah.
Now, I am loath to make a decision on whether this evidence comes in until I know what our position is in respect of all those 4 days. Now, if we were to take a further break, which we would be taking if I let the evidence in, you won't be able to talk to your experts in the States because of the time difference. But as to any other parties who would have to be available, you would be able to make contact with them, as I understand it. Is that right, Ms. Ahmed?
It is indeed, yes.
Mr. Kotick, do you agree?
Yes, we agree.
No. Well, how long do you think you need to be able to contact everybody other than the experts about those 4 days?
Not long at all.
Not long.
No.
Not long, Mr. Kotick, not long. Well, this has got an important bearing because one of the matters I have to give very careful consideration to when dealing with this application is the impact on the trial timetable. And I need to know before I can come to a final conclusion on the application how viable those additional 4 days are. Now, we're now on the hour or just before the hour. What do you want, half an hour, 30 minutes or less than that in order to come to a view?
I would say 15 minutes should be sufficient.
Ms. Ahmed?
I agree.
We
Mr.
agree as well.
Kotick, you agree? Okay. Right. We will resume in quarter of an hour's time at 1/4 the hour. Thank you very much. Thank you all for reassembling. We'll start with the claimant. What do you have to say to me, Ms. Stewart?
The issue is the transcribers can't do the 5th. From the claimant side, we can do any of the dates, which would, because of the lack of transcribers, be the 6th, the 9th, and the 12th.
Yes, thank you. Ms. Ahmed?
Your Lordship, we are able to do all the days, but we are still waiting to hear back from the expert. We won't hear back from him until about 6 or 7 this evening.
Yes, thank you.
Sorry, I should have said also we need to confirm.
Yes, of course, the experts we put to one side because of the time to Mr. Kotick.
Yes, Your Honor, as said previously, we are available for those 4 days, which is now apparently 3 days,
Right.
6th, the 9th, the 12th. And we cannot do it the 14th, 15th, or 16th should it be extended. So
Yes.
And we have confirmed with our expert.
Right. Thank you very much. Now I'm going to give a short ruling. Some time ago, this trial was fixed to begin on today's date, the 23rd of November. The action is a relatively heavy one in terms of evidence. The claimant was involved in a transaction which was intended to operate as a sale and purchase of Bitcoin, 300 Bitcoin. An individual had been identified as a prospective purchaser, and it was likely that he would operate through one of his companies as far as the legal technicalities were concerned. What happened was that although it was very much the intention of the claimant to ensure that the purchase price was either received in advance of the transfer of the Bitcoin or simultaneously with the transfer of the Bitcoin, the Bitcoin came to be transferred to the putative purchaser before any money had come from the purchaser. It's fair to say that it's common ground that the claimant has been the victim of a very serious fraud involving criminal dishonesty. It's the claimant's case that they had engaged the first defendant, who had available to them the experience and expertise of the second defendant, to assist in establishing a modality for the intended sale that would achieve the ambition of the claimant sellers, namely that the purchase price would be received in advance or simultaneously with the transfer of the Bitcoin. For reasons which are wholly unclear to the court, it appears that no civil proceedings have been launched against the purchaser. Instead, the claim is against the first and second defendants on the basis that there was a contractual or tortious duty to ensure that a transaction, the modalities of which were discussed, and the claimants say approved by them on the basis of advice from the first and second defendants. And accordingly, the first and second defendants are liable for the losses that have been incurred by the claimants resulting from transfer of 300 Bitcoin without any purchase price being received. Now, there was a timetable established for the service of evidence. The first evidential timeline was for the service of the first round of evidence, in particular that will be called by the claimant. And two witnesses signed witness statements on behalf of the claimant. Mr. Al-Ali and Mr. Saxena. There was a date set for the service of reply evidence, and reply evidence was served. Yesterday, the court received notice of an application by the claimants for permission to adduce further evidence from Mr. Al-Ali and Mr. Saxena, way after the time set in the procedural timetable for the service of evidence. The court inevitably has looked at the proposed new witness statements, one from each of these witnesses. To some extent, the new evidence serves to correct matters which were stated in the original witness statements. But it is plain that other matters that were not addressed in the first witness statements are for the first time referred to in the proposed additional witness statements. The general approach of modern commercial courts, as well as courts with general civil jurisdictions, is to be extremely hostile to late applications for the service of evidence, which is put before the court very, very close to the trial. In this case, it couldn't be closer, notice having been given only yesterday, at least so far as the court was concerned. In the old days, the attitude of the court was that if the matter could be, if the wheels could be oiled with adverse cost orders, then late evidence or late amendments would be allowed. And the whole trend of recent authority is to depart from that stance and generally to reject applications for late evidence on the basis that timetables are meant to be adhered to. The efficiency of the courts is dependent upon adherence of timetables. And accordingly, the general response to applications of the sort now made is to refuse them. Now, in this case, I propose to take an exceptional course and to allow these additional witness statements to come into the evidence. I do so for two principal reasons. Firstly, the timetable for the length of this trial was something of a work in progress. For some time, the claimant and the first defendant have been of the view that the original 5 days that were identified for the hearing of the factual and expert evidence wasn't sufficient. During these COVID times, the time differences between Dubai and where some of the counsel are and some of the witnesses are, mean that there is a shorter hearing day than is would otherwise be the course if all this could happen in an in-person hearing in Dubai. And accordingly, there was a real chance that the timetable for this trial would have had to have been extended, even if this application had not been put before the court. The second reason is this. I regard this as a very important piece of litigation. There's no doubt that the claimants have been the victim of a gravely dishonest misappropriation of its assets. There's no doubt that there were conversations and dealings between the claimant and the first and second defendant about the proposed claim. The second defendant's cases are that neither were under any contractual or tortious duty in respect of the transaction that was intended by the claimant. Conversations and the like are to some extent admitted, but both defendants maintain that there was no commitment which the claimants are entitled to rely on as to the provision of advice as to how the transaction was to be implemented. This case, therefore, very much turns on the evidence. And in my judgment, in the light of the overriding objective and how I perceive to be the justice of the situation that is currently before the court, exceptionally, I am going to allow this evidence to be adduced. I do so in the knowledge as to the time that is going to be required by counsel for first and second defendants to take on board this evidence to prepare their cross-examinations. I've been much assisted by the frank assessment that Ms. Ahmed, who will be the first cross-examiner, has provided to the court in estimating how much time she would require to be able to refashion her cross-examination in the light of this evidence. It seems that she would be able to get matters organized in 2.5 to 3 hours. The counsel for the second defendants have made it plain that they would need some time, but we're not going to hear any cross-examination from the second defendants during the rest of the day of this trial. With the assistance of counsel, the court has considered what is the availability of the respective legal teams and the witnesses for additional days to be added to the original 5 set down for the trial. As I have said, it was almost inevitable, despite the efforts from the bench to try and maintain a 5-day hearing span, that the number of days would have to be increased in any event for all the evidence to be heard. The position is that the legal teams and the factual witnesses would be available on the 6th and the 9th and the 12th of December. The 5th was proposed, but that cannot be effective because, for understandable reasons, a firm of transcribers have been engaged to produce a verbatim transcript of the proceedings, and they cannot attend for the 5th. Now, there are 3 expert witnesses, and I think at least 2 of them are in the United States. Because of the time difference, it has been impossible to consult those 2 experts as to their availability for the 6th, the 9th, and the 12th. In my judgment, given some flexibility on the part of the court, it is substantially likely that the expert evidence can be accommodated on any of the 6th, the 9th, or the 12th. If necessary, the expert evidence can be brought forward and can interrupt the other proceedings in the court, and those other proceedings can continue after the experts have been heard. In my judgment, there's not a great deal of expert evidence to be heard in cross-examination. There's broad agreement as to how it's probable that this outrageous fraud and theft was committed against the claimant, but there are some matters which are not agreed, which will have to be the subject of cross-examination. I've reached the conclusion, therefore, that this trial can remain on foot if the fresh evidence is admitted. And as I have sought to emphasize, in my view, this is what justice requires, bearing in mind that the impact on the trial is as I have described. Now, this ruling will come at a cost to the claimants. In effect, we're going to lose a substantial part of today. And I will order the claimants to be liable in costs to the first and second defendant in respect of the wasted costs of today. That is the least sanction that one can impose and about which the claimants can have no complaint. I turn then to what's to be done in the balance of the day. Now it's 25 to 11, which means that I think it's 25 to 3 in Dubai, if someone could nod. I'm not very good on time differences.
Yes, that's right.
So thank you. And now, if Miss Ahmed, if I say, can we start on the basis that it'll take 2.5 hours? If that turns out not to be, just is not possible, then I can be informed and we can take stock of the situation then. So let's imagine that in fact it's about it's 10:30. What would remain of a Dubai court day that's due to run until 6? I think it would be about an hour and a half, something of that sort.
That's right, yes.
Now, I think that it is worth adjourning until that point in time and then beginning the cross-examination. If it becomes clear that Miss Ahmed simply can't be ready in 2.5 hours, I'd like some forward notice of that, and we will resume and we'll take note of the situation. Now, allowing the 2.5 hours, the question is, what time in Dubai do we resume?
I think it's 4:30.
4:30, yeah.
Yes.
Yep. So the plan is that we will resume at 4:30 for an hour and a half of cross-examination. But as I say, if that turns out to be unfeasible, we will begin the cross-examination at some later point, either today or tomorrow. And so, therefore, matters that Council want to raise with me, that is my ruling, and we will stand adjourned until 4:30 Dubai time.
Just a minor housekeeping point, if I may. We seem to have attending the hearing witnesses, including an expert witness in the actual case. If any witnesses could not observe the case until they've concluded their evidence.
Well, why? That's not the usual order in these courts. What's the justification for that?
Well, purely that they will tailor their evidence accordingly.
Well, why should I assume that that's what's going to happen? I'm afraid I'm not going to, this isn't a criminal trial. Allegations of fraud and dishonesty are not made by the claimant against these defendants. And the usual rule can apply. And factual witnesses and the experts, if they wish, they can observe the proceeding. And bear in mind that the factual witnesses are, in any event, closely associated with the entities. Well, at least the first defendant is an entity, and the witnesses may well have executive, if not controlling responsibilities within the corporate reality of the first defendant. And as to Mr. Thurber, so far as Mr. Thurber is concerned, I see no reason to contemplate that he would improperly tailor his evidence in the light of how the cross-examination goes. It's very likely that there may be questions put to witnesses that arise out of the transcript of cross-examination. Who knows? But so that application is refused. And on that note,
we have 2 points quickly.
Yes.
Are we to assume that we are now waiving our opening submissions?
Well, we could have those, although Miss Ahmed is straining at the least to get on with preparing her cross-examination.
That's fine. And should, during this adjournment, Your Honor, should we take into account an assessment of our costs so that they can be included?
Yes, for the whole of the today's, I'm going to treat as a wasted day as a result of my allowing this application. So the wasted cost of the day, the the fees of the lawyers and any other expenditures which were incurred on the basis that there would be an effective day rather than this severely truncated day will be for the account of the claimants.
Okay, thank you.
Okay. Right, thank you very much. We're adjourned till 4:30.
Grateful, thank you.
Good afternoon, Mr. Al-Ali. This is the judge speaking. Can you hear me?
Yes, loud and clear.
Good. Now, you have probably been told this, but I shall say it in any event. All witnesses in this court must give their evidence either on a religious oath, a religious promise that it's true, or on a secular oath. Do you wish to take a religious oath or a secular oath in respect of your evidence?
Religious oath, please.
A religious oath. And would that be on the Quran, the holy book of the Quran?
It's here in front of me.
Yes. Would you take it in your right hand and listen carefully to me, and then I shall ask you a question. Do you solemnly and sincerely accept and agree on the holy book of the Quran that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you very much. You can put the book down now, and I'm going to put you back into the hands of counsel for the claimant. Yes, Ms. Stewart.
Mr. Al-Ali, please could you give your full name and place of work to the court?
My name is Sultan Muhammad Ibrahim Al-Ali bin Karsham Al-Ali. Currently, I have a company, my own company, Ordino SPS Accounting, providing accounting services and bookkeeping.
Right. I'm going to take you to 3 different documents in the bundle. And you may need some assistance at your end in terms of trying to find those documents. The first document is at 27-38.
Yes, I got it in front of me.
And this is a document titled Fifth Witness Statement of Sultan bin Karsham Al-Ali, yes?
Yes.
Do you recognise this?
Yes.
Can you now go to page 2746?
Yes.
Do you recognise that signature?
Yeah, that's my signature.
And are the contents of this witness statement true to the best of your knowledge and belief?
Yes.
Right, can I now take you to document at 6-1?
Yes, I got it in front of me now.
Do you recognise this document?
Yeah, this is my first witness statement.
Could you go to 6-29?
Yep, I got the bit.
Do you recognise the signature?
Yes, this is my signature.
So subject to the contents of the first document that I took you to, are the contents of this witness statement true and to the best of your knowledge and belief?
Yes.
Can you now go to 7-1?
Yes.
Do you recognise this?
Yes. The fourth witness statement.
Could you now go to 729?
Yes.
Do you recognise that signature?
Yeah, that's my signature.
Now, subject to the contents of the first document that I took you to, are the contents of this witness statement that I've just taken you to true to the best of your knowledge and belief?
Yes.
Thank you. Ms. Ahmed will have some questions for you now.
Yes, Ms. Ahmed.
Thank you, Mr. Al-Ali, you were taken to your fifth witness statement. That's at 27:38. Do you still have that witness statement open in front of you?
Yeah, give me a second.
Beg your pardon?
1 second, I'll just get it.
Thank you.
Yeah, now it is open.
Thank you. It might be useful to keep it open. Now, you say you filed this witness statement yesterday to correct factual errors. Is that right?
Yes.
Can I then take you to your first witness statement? That's at tab 6, page 1.
Yes.
This is date of the 10th of October. You see that date there on the top right-hand corner?
Yeah, I see the date.
Yes, and if you can then turn to 6:29, please.
Yes.
And you signed this document on the 10th of October, didn't you?
Yeah.
But this was in fact filed with the court on the 12th of October. So, Mr. Al-Ali, you had in fact 2 days in which to review this document and correct any factual errors, didn't you?
Well, see now, that's 29 pages of 2 years old case, and I don't think it's really.
I'm sorry, Mr. Al-Ali, I can't really hear you properly.
It is like, you mean, I didn't get your question clearly. Can you say it again, please?
Yes, Mr. Al-Ali, I'm asking you, Mr. Al-Ali, that this document was filed on the 12th of October, but you signed it on the 10th of October. So you had 2 days in which to review this document and correct any factual errors.
So you mean, why did I put another one? So
I'm asking you, why didn't you take the opportunity to read the witness statement on the date that you signed it, 2 days before it was due to be filed, to correct any factual errors?
But I read it. So I read it when I got it before filing it. I read it.
You read it?
Yeah.
But yet you didn't correct any factual errors that you now say were made in your fifth witness statement, did you?
When I reviewed all the conversation after that, I realized that there are few points need to be corrected. So I corrected them in the fifth witness statement.
Mr. Al-Ali, your fifth witness statement is not a few points. It's actually new and fresh evidence, isn't it? That you could have put in your first witness statement.
Sorry, I'm just entertaining my rights, isn't it?
I beg your pardon?
When I remember anything, I have to go put it for the court. I'm sorry, let me. Hello?
I'm sorry, this is Rachel from Opus 2. I won't be able to work with the sound quality of the witness, I'm afraid.
No, well, I quite understand. Now, do we have any IT people at hand who can get this sorted out? The problem is hearing and understanding the witness. As between the bar and the bench, everything is clear. Are
I'm
Charles Russell Speakley able to do something?
I'm wondering if a solution might be for there to be a swap between the rooms at Charles Russell's end. I'm just going to try and call them and see what's possible, because there seems to be some echoing where we are.
Could be because two microphones are on.
I'm very sorry. If we could have 10 minutes to try and move Mr. Al-Ali into a different room at CRS's offices. They don't know exactly what the problem is, but
Well, we will break for 10 minutes. You'll understand that my patience is beginning to wear really rather thin. Why proper preparatory steps were not taken to ensure that the location of the witness would serve well, both in terms of visual and audio reception, I do not know. So we'll adjourn for 10 minutes.
I do apologise.
Resume.
Sultan.
I'm just inquiring whether counsel for the first defendant is now back with us. Hello, Miss Ahmed.
Hello there.
Well, it sounds as if it all is now much improved, so may we proceed?
Your Lordship, in the adjournment, I took an opportunity to look at the video conferencing protocol that was agreed between the parties for the PTR.
Yes.
It's not in the bundle, unfortunately. I don't know why, but if you don't have a copy to hand, I can send it to you via an associate to the court who will hopefully pass it on. But there were a number of matters that were agreed in relation to witnesses in the video conferencing protocol.
Yes.
I wonder if I may just run through those matters very quickly with Mr. Al-Ali.
Yes.
But before I do, would your Lordship like a copy? Would you like me to send you a copy?
Well, I can, no, there's no need. I'll listen to you read out the relevant parts.
I'm grateful, thank you. Mr. Al-Ali, before we continue with your evidence, there was a video conferencing protocol that was agreed, and one of the agreed points was that all participants must be able to view the interior of the room in which the witness is located while retaining sufficient proximity to depict the witness. I appreciate that that's not possible at the moment given where your camera is. However, a further point that was agreed was that you as a witness would be sat in a separate room from the legal representatives on your own, save for a trainee from the legal representative's firm to assist with the bundles. Can I check, Mr. Al-Ali, are you sat on your own separate from your legal representatives, or are your legal representatives sat with you?
I've been in the room since morning on my own and just waiting there. Nobody was with me.
I'm grateful. And do you have anybody there to assist with the bundles? A trainee, for instance?
Yes.
And
she is here. Reem. She's just helping for the filing.
And do you mind identifying the name of the trainee?
Yeah, she can give you her name.
Hi, Ms. Ahmed. It's Reem Fakihi. I'm a junior associate with CRS, and I'm just helping Mr. Al-Ali with the bundles.
Thank you, Your Lordship. I'll continue. Now, Mr. Al-Ali, before we had the interference, I was asking you questions about your first witness statement and your fifth witness statement. And in response to one of the questions that I asked, and that was namely, why you changed your evidence from your first witness statement to that contained in your fifth witness statement. My understanding of the response was that you said, it is my right to change. Now, can I check, is that what you said in response?
Yes, I mean, whenever I remember something, I have to change it for the court. Otherwise, how would they know the truth?
Yes, but when you say it's my right to change, why do you say that?
To correct, you mean? Maybe I said change, but I meant correct. I can't give wrong things to the court. I have to give them the right things. Whenever I remember something is right, I'll give it to the court.
Well,
I'm under oath, I cannot lie.
I apologise for interrupting. Well, let me ask you this question. If you can go back to your first witness statement, that's at 629, please.
629.
Yes. That's your statement of truth.
Yes, I got it.
Yes, and you have to confirm that you believe that the facts stated in this first witness statement are true. Do you see that?
Which one? Which point? Sorry.
Section 6, page 29.
Yeah.
That shows your statement of truth. See that there?
I believe the fact is yes.
Yes, that's at the bottom.
And you've signed to confirm that the facts in this first witness statement are true.
Yes.
Before signing that statement of truth, were you given a warning by your solicitors as to the effect of signing this statement of truth?
They asked me about the incidents. I gave them all the details I remember at that time. And they told me that this is a witness statement which will go to the court and explain to me that how critical it is. Yes. Now, after that, I was going through all the evidence again and again in the last 1 month. And I think you would appreciate this incident almost a year, more than a year ago. So when I was going through all the evidence, all the messages, communication, I started recalling some things in between incidents. And so I started updating them. I said, okay, listen, guys, in my first witness statement, I said this, but now I remember that there was additional happened. So I keep updating them.
So, Mr. Al-Ali, are you saying that when you prepared this first witness statement, you in fact did so without any reference to any documents and you didn't go through the documents?
I did. But have you seen the files? It's a huge file. I mean, it's even if I go to them 1 or 2 times, I'll still need to go more and more to them.
And in terms of your fifth witness statement, the statement of truth there is at page 20, section 27, page 46.
Yeah.
You also confirm there that the facts stated in that witness statement are true, don't you?
Yeah, you mean you're referring to the last page?
Yes, I am.
2746.
Yes.
Yes.
So, Mr. Al-Ali, you confirmed there that the facts stated in that witness statement are true, don't you?
Yes.
So, we have 2 witness statements in which some evidence is inconsistent and contradictory. Which witness statement are you asking the court to rely on and to accept?
See, now it's very clearly what I mentioned in the fifth statement, that this is referring to the first and fourth statement. And whatever I corrected here in the fifth statement is my final and remembering on the incident.
So, are you saying, therefore, that the contents of the first witness statement are not true?
No, I'm saying the fifth witness statement is true also. But there are things which I remember late. I said them in the first witness statement. I update them for the trial.
Can I ask you to turn up section 9242, please?
Yes.
Do you have that there?
Yeah.
This is a WhatsApp chat, and you were a participant in this WhatsApp chat, and I can say that you were. If you turn up 9223, please. So this is a message. This is a message report that covers the WhatsApp messages on 9242, and it shows messages, total messages 464, and it also shows that you are a participant in this WhatsApp chat. Do you see that there at 9223?
Yeah.
So you accept you are. Can we then go back? Thank you. Can we then go back to 9242, please?
9424.
9242, please.
24. Yeah.
And these are WhatsApp messages between the participants, Mohit, and that's Mohit Davar, isn't it?
Yes.
Mr. Shantanu Saxena, and Mr. Saxena is a witness as well on behalf of the claimant, and yourself.
Yes.
On the 6th of February 2020, which is 3 days after the theft of the 300 Bitcoin, isn't it?
Yeah, after that. Yes.
Sorry, did you say 3 days before or 3 days after?
3 days after.
Thank you very much.
And if we see at the top of the page, on the 6th of February 2020 at 12:12 a.m, Mr. Davar is asking Mr. Saxena, isn't he, to prepare a summary of the OTC deal. And that's the OTC deal that took place or did not take place on the 3rd of February, isn't it?
So again, sorry, you mean the deal happened on the 3rd of February?
Yes. And Mr. Davar is asking Mr. Saxena to prepare a summary of what happened, because China, which is HUOBI Global, which was your JV partner, needed to be notified, didn't it?
Yes.
And Alan is a member of the team at HUOBI Global, wasn't he?
Yes.
What was his role in HUOBI Global?
He's more of an advisor role.
Advisor in what sense?
To them, like not to us. So maybe it's more mainly many of your communication, because he's a good language English speaker, and then most of the team there, they don't speak English.
No, Mr. Alali, that's fine. Thank you.
Okay.
Thank you. Please prepare and can you see the last sentence in that first WhatsApp message? Please prepare and send to Sultan and me only for now. Sultan is reference to you, isn't it, Mr. Alali?
Yes, yes.
So then we go down the page, 1, 2, 3, 6th entry down at 5:34 a.m. Mr. Saxena says, you mean summary report of this deal with TABARAK? Yes, the coins have now moved to multiple wallets, and that's in respect of where the coins are. Do you see that there?
Yes, yes.
And then the next entry is Mr. Saxena saying, I understood, we'll prepare a summary of the OTC TABARAK deal. Yes?
Yes, the next one from Shantanu again, yes.
And then if we go down the page, at 4:45 p.m, Mr. Saxena is saying modified a little more. Do you see that?
Yeah.
So presumably at some point, the first draft of the report has been sent, and Mr. Saxena is modifying it a little more. Yes?
The report here and the WhatsApp messages?
Yes, the report that's referred to in the WhatsApp messages about the intended transaction with Tabarak on the 3rd of February.
Yeah, I can check that.
Can you then turn to the next page, 9243, please? And what Mr. Devar says is that he made some changes. Can you see that at 8:59?
Yeah.
Now, Mr. Devar was not at the meeting on the 3rd of February at Tabarak's offices, was he?
No.
At no point was he present on the 3rd of February in relation to the intended sale of the 300 Bitcoin to the buyer, was he?
No. But I don't know the content of the report.
And at 11 o'clock at night, having had this report for about 2 hours, Mr. Devar responds, I will add the line, but we need to make sure in all your statements to the lawyers and police, etc., you stress that it was at the explicit assurance of Christian and then the Tabarak CEO, you transferred them coins to them as escrow agents while the funds from the buyer were still being wired. Do you see that there?
Can you refer which page is it?
It is 9, section 9, page 243, the entry at 11 o'clock.
Yeah. Yep.
You've read it?
Yeah.
So what's happening there? Mr. Saxena provides a report. It's modified once. It's sent to Mr. Devar, and Mr. Devar modifies it some more, doesn't he?
Well, he proposes that it should be modified.
Yeah, I can't say anything on this because I don't remember which report you're referring to. And
well, Mr. Al-Ali, you are part of this chat.
Yeah, but see now, I need to go back and check the report because this is after the incident. The report, it could be a financial which was sent to China because China, they were not interested like about the police report, about this. For them, it's just even one word. We say to them, this has been reported, would be enough, and action has been taken.
Mr. Al-Ali, there is no basis upon which Mr. Devar could have modified the report because he wasn't even present on the 3rd of February, was he?
No, but he was updated on the rates and the numbers and like the 61 and the cost, even he was in control.
Can you hear me? Hello?
Yes.
Oh yeah, sorry, Mr. Al-Ali, we can't hear you.
No, he was in charge of the...
Oh, wait a moment, I'm sorry, Mr. Al-Ali.
Yeah.
Ms. Ahmed.
Mr. Al-Ali, we can't hear you.
Well, I
can. The rest can hear me?
I can hear him.
Yes.
The register speaking.
You can hear Mr. Matu, you can hear him.
I think she has no problem there in hers.
Mr. Matu, can you hear me? I think you're muted at the moment.
Yes, we can hear you.
Yeah, and you can hear the witness, can you?
Yeah.
Yes. Well, the problem seems to be at Miss Ahmed's end.
I apologise, I think off there and back.
Well, shall we carry on and see if you can hear the witness now, Miss Ahmed?
Can you hear me?
I can, Mr. Al-Ali.
Okay.
Good. So let's get on.
Yeah, so Mr. Al-Ali, the question that I'm putting to you is that the report that Mr. Devar was proposing to modify was the summary of the OTC Tabarak deal that Mr. Shantanu was preparing, wasn't it?
Yeah, it could be the financial part of it.
But it doesn't say that. How do you know that, Mr. Al-Ali, it could be the financial part?
I don't know. It could be the financial part. I'm just saying because you're also assuming that it could be something else.
Well, let's look at this. The message at 11 o'clock, we need to make sure in all our statements to the lawyers and police, you stress that it was at the explicit assurance of Christian and then TABARAK that you transferred coins to them as escrow agents. So Mr. Al-Ali, the modification that he was proposing to make was a statement that Christian had given his explicit assurance and TABARAK CEO had given his explicit assurance to transfer the coins to them. That's what he was proposing to change, wasn't he, in the report?
Well, wait a minute, Ms. Ahmed, I'm sorry. He does say to stress. He doesn't say necessarily to introduce.
Yes.
I don't want to be too picky about this.
Well, Mr. Al-Ali, let me put a different question then. Mr. Devar wasn't present on the 3rd of February, so he can't say, can he, what assurance was given by Christian or TABARAK CEO, can he?
That is 3 days after the incident. We have several calls and we explained to him what had happened. He had a call with me, he had a call with Sushant, he had a call with Shantanu, all the three of us. We had a call. I mean, you think it's like 3 days after, nobody will talk about it. We have several conversation and exactly what had happened during the incident.
And Mr. Al-Ali, the reason why you are now bringing this case, that it was on the assurance of Christian and the TABARAK CEO that you transferred coins to them as escrow agents, is because that was the line that you were asked to pursue by Mr. Devar.
No.
Mr. Al-Ali, can I ask you to turn up section 8, page 620, please?
But that what happened? Sorry, again, which page?
Yes, section 8, page 620.
$620, yeah.
Do you have that there, Mr. Al-Ali?
Yeah, that's my CV.
Yes, it's your CV. So, Mr. Al-Ali, your CV tells us that you're a businessman with excellent communication skills and you pride yourself on establishing sustainable and profitable relationships. Yes?
Yes, thank you.
And it also says on the left-hand side that one of your top skills is banking.
Yep.
And therefore, we can presume reading this that you understand how banking systems work, don't you?
Just for information, this is a LinkedIn page printed out. And in LinkedIn, they give you a category of banking. So it doesn't really say exactly what kind of specific profession in banking. So in here, yes, we dealt with so many banks, locally and globally, yes.
So, Mr. Al-Ali, are you saying that this is not correct?
No, I'm saying it's correct. But,
Right.
you know, this is what is in the system. I have no control on that.
Well, let me go back to my question then. Are you saying that your top skill now is not banking?
Well, that is what is there in the selection. So banking in general, it says whether it's communication with the banks, dealing with the banks, it doesn't mean even working with the bank will select also the same category. So I think this is not something I have a control on. You select what is kind of profession you came across in LinkedIn. So LinkedIn, for example, here like business development and business strategy. So all these categories are there. So even if you've done something which is even partially of the profession, you can select in that profession. Even if you dealt with the banking, you said, yes, I've dealt with the banking. And business development, if you start preparing some setting up a business, starting up a business. That's considered, but it doesn't mean that you are completely a professional in that. It does. You worked in it. You did some work. Yeah.
Mr. Alali.
Yeah, I'm just explaining to you what is the.
Mr. Alali, I'm very limited by time, and therefore, please, I ask you, make a very kind request that you stick to the answer, please, to the question.
Yep.
Mr. Alali, I'm going to suggest to you that you are, in fact, a person who understands how banking systems work, don't you?
Yes.
And you understand, don't you, that it may take up to 24 hours to effect an international transfer?
Yeah. Yes.
Especially if it's of a significant sum of money.
See, now we've seen some transaction happen a bit more than 24 hours.
So it could take longer than 24 hours. You accept that?
Yeah.
And you also appreciate, don't you, the importance of compliance issues within a banking relationship?
Yes.
And you also appreciate, don't you, that in order to provide services, a regulated entity must comply with due diligence requirements from an AML perspective?
Yes.
You would also appreciate, wouldn't you, that a regulated entity has to ascertain the provenance of funds?
Sorry, again, can you repeat that again?
A regulated entity is required to ascertain where money is coming from, the provenance of funds.
Can you rephrase the question? Sorry. See, originally it's I'm not native English, so can you use like a simple word sometime in some places?
Yes,
it's just,
Mr. Alali, my apologies.
I don't want to give you any wrong answers.
I understand, Mr. Alali. Thank you for pointing that out. If you don't understand the question, please ask me to repeat it, and I will. My question was: you understand and you appreciate that a regulated entity needs to be sure where monies are coming from when they come into their account.
Yes.
And therefore, it's important for a regulated entity to adhere to its regulatory requirements.
Yes.
In late 2019, you understood, that TABARAK was not a bank, but a DFSA regulated financial institution in the DIFC.
Investment banking, yes.
Investment bank or asset management company?
Well, they explained to us their services, but as a investment banking.
Now, in terms of HUOBI MENA, and when I refer to the seller in the transaction, I'm going to refer to HUOBI MENA. In terms of HUOBI MENA, that was set up in September 2018 with Mr. Mohit Devar, wasn't it?
Yes.
During the period relating to the intended sale and purchase of the 300 Bitcoin, and I'm talking about the period December 2019 to February 2020, Mr. Devar was somebody who was in constant communication with you about the intended sale and purchase, wasn't he?
Yes.
And amongst other things, during that period, there were numerous discussions about how to generate profit for HUOBI MENA, wasn't there?
Yes.
There were also discussions about how HUOBI MENA could bring in clients.
Yep.
You also discussed during that period the buyer, Mr. Morozov, didn't you?
Yes.
And you also discussed the buying and selling of Bitcoin between HUOBI MENA and Mr. Morozov.
Yes. You mean using our own coins to sell to him?
No, I'm just talking about a sale and purchase of Bitcoins.
See, normally we don't. Well, it's not really exactly as you.
Yes.
Yeah. So you want me to explain it, or I don't know what is want
I'm sorry, I didn't realise that you hadn't finished. There was an interference with the connection. Yes, please continue.
You said sales and purchase agreement with the buyer?
My question was that you and Mr. Davar were in constant communication between December 2019 and February 2020 about the intended sale and purchase of Bitcoin between HUOBI MENA and the buyer.
Yes, there was communication about selling to, yes.
And can I invite you to turn up section 6, paragraph 3, page 3, paragraph 9b. This is your witness statement.
Which, sorry, again?
Sorry, what's that?
6.3, paragraph 9b.
Okay.
And if you turn over the page at 6.4, sorry, we'll start from 6.3. Mr. Mohit Davar is also a co-founder and a director of HUOBI MENA and HUOBI. I am told by Mr. Davar and believed to be true based on our several years working together that he has a great deal of experience in cryptocurrency businesses. You see that there?
Yep.
And so it's right, isn't it, that Mr. Mohit Davar is a person who knows a lot about the buying and selling of cryptocurrency.
Fair, I would say, yeah. You know, see now there's very complication in the crypto environment. It's not only as simple as that. So there is so many divisions, so many different. So yes, I would give him a good experience in dealing.
Yes, and Mr. Davar is also somebody who would have the necessary knowledge and skill of how to establish the modality of an intended sale and purchase of Bitcoin.
Can you rephrase the question, please?
I apologize. Mr. Davar, because he has a great deal of experience in cryptocurrency businesses, is somebody who would be able to know and establish a process for the sale and purchase of Bitcoin, for the buying and selling of Bitcoin.
Yes.
And Mr. Saxena, we're going to hear from him. Now, you say, if I'm correct, that he's an OTC trader. Is that correct?
That's Sushant, yes, not Shantanu.
That's Sushant. And Mr. Sushant, as an OTC trader, is also somebody who would know about the process of buying and selling Bitcoin, wouldn't he?
Yes.
And Mr. Saxena then, he is, from what we read in his witness statement, a strategy planner and is knowledgeable about, well, he's a strategy planner, isn't he?
Shantanu, you mean?
Mr. Saxena now, I'm talking about Mr. Saxena.
Yes.
And therefore, he is also knowledgeable, isn't he, about the buying and selling of Bitcoin?
Yes.
And Mr. Al-Ali, you yourself have experience and knowledge about buying and selling Bitcoin, don't you?
Yeah.
And so you are people that are able to put together a process for the buying and selling of Bitcoin.
Yeah, if it's required, we can make a process, yes.
Now, in terms of the business, HUOBI MENA business, can I invite you to turn up section 8, page 607, please? And your lordship, it's 6 o'clock.
Yes, can we do this, take this topic, if it's not going to be too long, and then we'll stop. Carry on, as long as it's not going to be a lengthy series of questions. Otherwise, we'll stop now, and you can start with it again. Would you rather stop now?
Yes, please.
Yes. Right, Mr. Al-Ali,
Yes.
please listen carefully to what I'm going to say.
Yep.
There is a rule that applies to all witnesses, and I say this to every witness, that when the court adjourns, but you have not finished your evidence, so you'll be back tomorrow to continue,
Okay.
it's very important you do not talk to anybody about this case.
Yes.
You understand? In particular, you don't talk to any of your business associates, you don't talk to any of the lawyers, indeed you don't talk to anyone, even a member of the family, about this case. There are lots of other things which are nice to talk about. This is your unperda so far as this topic is concerned. Good. Thank you very much. We shall resume tomorrow at the start time of 12:30 Dubai time. And let's hope that all glitches will have been banished and we can make good and smooth progress. Thank you very much.
Thank you. Thank you.
Thank you.
Thank you.